Hello everyone, in this video we are gonna study the remaining subchapters from Sale of Goods Act 1930 from Business Laws and Ethics. The first part, that is the first subchapter, has been already uploaded. So let's move on. Transfer of ownership. So it is the most important part, and let's see when exactly the buyer becomes the owner. So under section 18, first rule is that goods must be ascertained. Property in goods cannot pass to the buyer unless the goods are ascertained. That means identified. So ascertained means we know exactly which goods are being sold. The second one is intention of the parties, that comes under section 19. So the property in goods passes when the parties intend it to pass. This is the golden rule. The act respects what buyer and seller wanted. To find this intention, we consider terms of contract, that is what is written or said, conduct of the parties, that is how they behave, and circumstances of the case, that is full situation around the deal. If intention is not clear, then sections 20 to 24 give rules to determine when property passes. These sections are default rules that apply only if contract is silent. Okay, so let's see. Section 20, specific goods in a deliberate state. If the contract is for specific goods and the goods are in deliberate state, the property passes to the buyer when the contract is made. Deliberate state means the seller has done everything needed and the buyer can take goods immediately without seller doing anything more. It does not matter whether payment is delayed or delivery is delayed. Now let's move on to the next topic, that is section 21, that is specific goods to be put into deliberate state. So continuing from section 20, now section 21 covers a different case. If the seller must do something to make the goods deliverable, the property passes only after the seller completes that act and the buyer knows about it. So deliverable state means buyer can take goods immediately. If seller still has to repair, pack or finish the goods, ownership does not pass. Now section 22, that is seller must determine price. So here goods are already in deliverable state but price is not fixed yet. If the goods are deliverable but the seller must weigh, measure, test or do something to fix the price, the property passes after the act is done and the buyer is informed. Section 23, unascertained goods. These are goods not identified at the time of contract. First one is goods sold by description. That means these are not specific and property passes when goods matching the description are appropriated to the contract and the buyer agrees to it, either expressly or impliedly. And the appropriation means seller sets aside goods for the buyer, like packing and writing buyer's name, or goods are delivered to a carrier for delivery to the buyer. So section 21 and 22 delay ownership till seller's act is done. Section 23 says for unascertained goods, ownership passes at appropriation. Let's move on to the next topic, that is section 24, that is goods on approval or sale or return. So this covers a very common business practice. Here buyer takes goods first, checks them and then decides whether to keep or return till buyer decides who is the owner. So property passes to the buyer when buyer approves or accepts the goods, when buyer keeps the goods beyond fixed time and when buyer keeps goods beyond reasonable time. Now let's move on to the 25th section, that is reservation of right of disposal. And this is the opposite concept. This protects the seller. When there is contract for sale of specific goods or goods are appropriated to the contract, the seller may reserve the right of disposal until certain conditions are fulfilled. Meaning, even if I give you the goods, I can still remain the owner until you fulfill my condition. So this is all about reservation of right of disposal. So section 24 lets buyer decide ownership by action, and 25 lets seller delay ownership despite delivery. Both override normal rules. Okay, then we'll move on to the next one. Railway receipt in seller's name, that is subsection 2 of section 25. So in section 25 subsection 1, said seller can reserve ownership. In subsection 2 shows how sellers do this in practice with transport documents. So if seller delivers goods to railway administration or a carrier for sending them to the buyer and takes the railway receipt or billing of lading in his own name, then the seller reserves the right of disposal. The property does not pass to the buyer. Why? Because whoever holds the railway receipt or bill of lading controls the goods. If seller keeps the document in his own name, the railway will release goods only to the seller or his order. The next one is subsection 3, document sent with bill of exchange. So this explains what happens next. If the seller sends the bill of lading or railway receipt to the buyer along with the bill of exchange for payment, the buyer must accept or pay the bill of exchange to receive the document. So section 25 subsection 2 and subsection 3 are used heavily in export, import and credit sales. Seller uses transport documents to keep control till he gets paid. Now let's see an example of bill of lading in seller's name. Mr. Isaac Company Limited sends goods by ship to Mr. Norman in Karachi and takes the bill of lading in his own name. Because the bill of lading is in the seller's name, the seller has reserved the right of disposal under section 25 subsection 2. So even though goods are traveling to Karachi, Mr. Norman is not the owner yet. Isaac and Co. is still the owner. Let's move on to the next topic, the effect of destruction of goods under section 26. This is the golden rule of risk. So unless otherwise agreed, the goods remain at seller's risk until the property passes to the buyer. After the property passes, the risk passes to the buyer even if the delivery has not been made. The key word here is property, not possession or delivery. Risk follows ownership. This means if goods are destroyed before property passes, the seller bears the loss. If goods are destroyed after property passes, the buyer bears the loss. So section 25 controls ownership using documents and section 26 says risk follows ownership. Always check when property passes to know who bears loss. Okay, so the next topic is risk prima facie passes with property exceptions. Prima facie means at first sight or general rule. But this rule has 4 important exceptions where risk and ownership separate. First one is agreement between parties. So agreement between parties, the rule applies only if there is no agreement to the contrary. The parties can decide who will bear the risk. So this is freedom of contract. Second one is delay in delivery. That is, if delivery is delayed because of the fault of the buyer or seller, the party responsible for the delay bears the risk of loss during that time. So this is fault rule. The third one is trade custom. So if there is custom in a particular trade that risk does not pass with property, then that custom will apply. The fourth one is seller agrees to deliver at buyer's place. This is the fourth exception. If the seller agrees to deliver goods at the buyer's place, the risk remains with the seller during transit, even though the property in goods has passed to the buyer. Let's move on to the next topic, that is transfer of title by non-owners under section 27 and exceptions. So this is all about no one can give what he does not have. So only the owner or someone authorized by the owner can give a valid title. If non-owner sells goods without authority, the buyer does not become the owner, even if they put in good faith. So let's see the exceptions. First one is when non-owner can pass good title. But businesses would stop if this rule had no exceptions. So the Act gave cases where a buyer gets good title even from a non-owner. The first one is mercantile agent sale. So a mercantile agent is like a dealer or a broker. He can pass good title if agent has goods or documents with owner's consent, sells in document ordinary course of business, and buyer acts in good faith without knowing agent lacks authority. The second one is transfer by estoppel. So if real owner's conduct makes it look like the seller has authority, the owner cannot later deny it. So estoppel means you can go back on your words or actions. The third one is sale by joint owner. And this comes under section 28. So one joint owner in sole possession with permission of co-owners can give good title if buyer acts in good faith. The fourth one is sale under voidable contract. So this comes under section 29, and if seller has goods under a voidable contract, they can pass good title if buyer acts in good faith and without notice of defect. So voidable contract means which can be cancelled, like fraud. Now let's move on to the next exception, that is seller in possession after sale under section 30. So this continues the exceptions that is section 30 subsection 1, seller in possession after sale. So the seller who already sold goods but still holds them or documents can resell. This happens when seller keeps possession even after ownership passes to first buyer. Then second buyer gets good title if acting in good faith without notice of earlier sale. Section 30 subsection 2 is buyer in possession after agreement to buy. So buyer in possession after agreement to buy states buyer who agreed to buy and possession with seller's consent can resell. This is common in hire purchase or installment sales. That is, buyer has good but it is not owner yet. Now buyer gets good title if acting in good faith without notice of seller's rights. Then the other acts where non-owners can pass title is whereby sale by official receiver or liquidator. That is, when a company goes bankrupt, liquidator can sell its assets. As well as sale by finder of lost good, that is under conditions. And the third one is sale by pawnee or pledgee. That is, if you pawn gold and don't repay, pawnbroker can sell it after notice. So the next topic is unpaid seller's right to sell. So an unpaid gets right to resell in 3 cases. If goods are perishable, if resale right is reserved in contract, and if buyer defaults in paying with reasonable time. So if goods are perishable, like in case of fruits, milk, seller need not wait. And third one, if buyer defaults in paying with reasonable time, after notice, seller can resell and claim loss from buyer. Let's move on to the next subchapter, that is the third subchapter, conditions and warranties. So this comes under section 12 of Sale of Goods Act 1930. So it states that a stipulation in a contract of sale may be condition or a warranty. So stipulation means any term or promise in the contract, but not all terms are equal. Some are important, some area are less important. These terms determine the rights and remedies of the buyer and seller when contract is breached. So breach means breaking the promise. The next one is what is meant by condition under section 12 subsection 2. So subsection 1 tells what is condition or warranty. So a condition is a stipulation essential to the main purpose of the contract. So essential means it's the heart of the deal. That is, without this term, the contract has no meaning. Breach of a condition gives the buyer the right to repudiate the contract. So repudiate means cancel or reject. So buyer can return goods and gets full refund. Next topic is warranty under section 12 subsection 3. So warranty is a stipulation collateral to the main purpose of the act. So condition is a stipulation to the main purpose and warranty is collateral to the main purpose. So this collateral means secondary or side promise. The main deal still stands even if this term is broken. Let's see a difference between condition and warranty. So condition is essential to the main purpose of the contract, that is, it is the foundation. If it breaks, the contract collapses. On the other hand, warranty is collateral to the main purpose. That is, it is a side promise. If it breaks, the contract still stands. The second one is about remedy, that is, breach of condition allows repudiation of contract, that is, buyer can reject goods, cancel the deal and get money back plus claim damages. Next one is breach of warranty, that is, only damages can be claimed. Buyer must keep the goods, he cannot reject, he can only ask for money as compensation. The third one is conversation rule, that is, this shows a special rule. So breach of condition may be treated as a breach of warranty. This means, now let's move on to the next topic. When condition is treated as warranty under section 13 and remedies for breach of conditions. So section 12 told us condition means cancel and warranty means damages. So 13 tells us when a condition loses its power to cancel. So first one, the buyer waives the condition. That is, waive means the buyer says, I don't insist on this term. Second one is the buyer chooses to term the breach of condition as breach of warranty. Even if seller breaks a major term, buyer can voluntarily say, I won't cancel, just pay me damages. This is buyer's choice. The third one is when the contract is not severable and the buyer has accepted the goods or part of the goods. So in such cases, the buyer cannot repudiate the contract but can claim damage. Let's move on to the next topic, that is remedies available to buyer for breach of conditions. So what exactly can a buyer do if a condition is breached? So the buyer has two options: reject the goods and claim refund of the price, treat breach of condition as breach of warranty and claim damages. So section 13 gives flexibility. Buyer can downgrade a condition to warranty but cannot upgrade a warranty to condition. And once goods are accepted, rejection right is gone. Now let's move on to the next topic, that is consequences of breach of warranty. When a warranty is breached, the buyer cannot reject the goods. The buyer can only claim damages. And the buyer may file a suit for compensation and no remedy if fulfillment becomes impossible by law. Now the next topic is implied conditions in contract of sale. So these conditions are automatically adds to every contract even if buyer and seller didn't write them. They protect the buyer. So section 14 says condition as to title. First condition as to the title under section 13, seller must have the rights to sell the goods. This means seller must be the owner or have owner's authority. Section 15 says sale by description. That is, goods must correspond with the description given. If you buy goods based on what seller said or wrote, the goods must match that. Section 16 says condition as to quality or fitness. Goods must be fit with the purpose intended by the buyer. Buyer tells seller the purpose. Buyer relies on seller's skill or judgment, and seller sells goods of that description in normal business. Let's move on to the next topic, that is caveat emptor principle. And it means let the buyer beware. This is the starting point of section 16. The buyer must check the quality and suitability of goods before purchases. That is, the seller is not responsible if goods turn out useless for your purposes. Law says it's your job to choose carefully. But this rule has many exceptions, that is section 14 to 17 are all exceptions to caveat emptor. They protect the buyer. Next one is sale by sample under section 17. So when sale is by sample, law adds 3 implied conditions to protect the buyer. The bulk of goods must correspond with sample in quality. The buyer must have reasonable opportunity to compare the bulk with the sample. And the goods must be free from hidden defects that are not visible during sample inspection. Let's see an example of sample, that is sale by sample. So David sells sunflower seeds and shows a sample to Tatiana. And Tatiana orders seeds in bulk based on the sample. Later, she discovers the seed supplies are different from the sample. So here the result is that the David must refund the price or replace the goods. Because implied conditions under section 17 is broken, Tatiana can repudiate the contract. Now let's move on to the next topic, that is implied warranties and doctrine of caveat emptor. So we saw implied conditions under section 14 to 17. Now we have implied warranties. So remember, breach of condition means rejection of goods and breach of warranty means damages only. So these warranties are automatically added by law to every sale. So the first one is warranty of quiet possession, section 14 subsection B. So warranty of quiet possession, the buyer should enjoy peaceful possession of goods without disturbance. That means after you buy, no one should trouble you claiming these goods are mine. Second one is warranty of freedom from encumbrances, that is section 14 subsection C. That is warranty of freedom, that is goods must be free from any charge or claim by third parties. So encumbrance means loan or mortgage or charge. The third one is warranty as to quality by usage of trade. So trade practices may create additional warranties regarding the quality. If a particular trade always assumes certain quality, law implies it. The fourth one is warranty to disclose dangerous nature. So seller must inform the buyer if goods are dangerous. If goods can cause harm, seller must warn. Now let's move on to the next topic, that is doctrine of caveat emptor. So this means let the buyer beware. The buyer must examine goods before purchasing. The seller is not responsible for the defects. So this is the default rule, but implied conditions and warranties we studied under section 14 to 17 are exceptions to caveat emptor, and law protects buyers when seller knows more or when the buyer relies on seller. Now let's move on to next topic, exemptions to the doctrine of caveat emptor. So section 16, we saw caveat emptor means buyer beware, but section 16 gives important exceptions where seller becomes liable. So first one is fitness for buyer's purpose. If buyer informs the seller about the specific purpose of goods and relies on the seller's skill or judgment, then goods must be reasonably fit for that purpose. The second one is merchantable quality, that is when goods are bought by description from a seller who deals in such goods, there is an implied condition that the goods must be of merchantable quality. Merchantable means fit to sell, that is no major defects, that is acceptable quantity for that price is known as merchantable. So the next one is usage of trade. So trade practices may cause implied conditions or warranties, that is some industries have standard expectations. Law implies them automatically. Next one is express and implied condition, and an express condition or warranty does not cancel an implied one. Express means written or spoken by parties and implied means added by law. So it only overrides it if both are inconsistent. For example, law implies goods must be fit for the purpose. If contract says no warranty on fitness, then express term is inconsistent and overrides implied one. But if contract is silent, implied condition stays. Now let's move on to the fourth subchapter, that is performance of the contract of sale. So this comes under section 31. The contract creates two core duties. That is, the seller must deliver the goods and the buyer must accept and pay for them according to the contract terms. So this is the heart of every sale. If either party fails, it is breach of contract. So let's see what performance of contract involves. So this involves 5 steps. Payment and delivery are concurrent conditions. Delivery of goods, buyer's right to examine goods, acceptance of goods and buyer's liability. Now let's see the payment and delivery. So payment and delivery are concurrent conditions unless otherwise agreed. That is, concurrent means at the same time. So it is cash and carry. This means seller must be ready and willing to give possession of goods. Buyer must be ready and willing to pay the price in exchange for goods. Both actions normally occur at the same time, right? Okay, then example of payment and delivery is given. The next topic is delivery of goods. This comes under section 33. What counts as delivery in law? So delivery may be by doing anything agreed by parties or by any act that puts the goods into the possession of the buyer, or goods may be also delivered to a person authorized by the buyer. So delivery is flexible. It is not just a physical handover. It is any act that gives buyer control as per contract or possession, and it must be matched with payment unless credit was agreed. Now let's move on to the next topic, that is when seller is bound to deliver. Comes under section 35. Seller is not bound to deliver goods until the buyer applies for delivery. That is, seller can sit quietly. He has no duty to run after the buyer saying, please take your goods. So it is buyer's job to say, I am ready, give me delivery. The next topic is part delivery under section 34. So delivery of part of the goods may be treated as delivery of the whole if done to transfer ownership. So if part delivery is done to separate goods from the bulk, it does not count as delivery of the whole. Then the rules as to delivery, section 36. So these apply unless otherwise agreed. So first one is place. Goods must be delivered at the place where they are at the time of sale. So for example, you buy a car from a showroom in Kochi. Seller need not bring it to Malapalli. You must collect from Kochi. The second one is manufactured goods. So if goods are to be manufactured, delivery occurs at the place of manufacture. So for example, you order custom furniture. Furniture is in Kottayam and delivery point is also at Kottayam and not your house, unless contract says home delivery. Third one is time. If the seller must send goods to the buyer, delivery must be within a reasonable time. So reasonable, it depends on distance, goods type, trade practice, and it's not fixed. The fourth one is third person possession. If goods are in the possession of a third person, delivery occurs when that person acknowledges holding goods for the buyer. Fifth one is expenses, that the seller must bear the expenses. Now let's move on to the next topic, that is time and expense of delivery and delivery of wrong quantity. So the delivery and payment must be done within a reasonable time if no time is specified. Reasonable time is not defined. It depends on nature of goods, distance, trade, custom. So perishable goods means it must be reached within hours and heavy machinery must be within weeks. So seller bears expenses for making goods ready for delivery. So the next topic is delivery of wrong quantity under section 37. So if the seller delivers a wrong quantity, the buyer has certain rights. Law gives buyer options because seller broke the contract term on quality. First one is less quality delivered. So buyer has two options. Buyer may reject the goods, accept them and pay at the contract price. The second one is more quantity delivered, that is accept the contracted quantity and reject the rest, reject the whole delivery and accept all goods and pay for all. Next one is mixed goods delivery, that is if goods are mixed with different goods, meaning seller send wrong type along with right type. So there also buyer may accept goods that match the contract or reject the rest or reject the whole delivery. Now let's move on to the next topic, that is delivery by installments. So delivery may be made in installments if agreed in the contract. Buyer is bound to accept installment delivery unless the contract allows it. So if either party fails to perform one installment, it may be treated as breach of whole contract or only a separate breach depending on circumstances. Let's move on to the next topic, that is delivered to carrier or wharfinger. So here wharfinger means person who manages a wharf or dock. When the seller delivers goods to a carrier for transmission to the buyer, it is treated as delivery to the buyer. But seller has duties. The seller must make a reasonable contract, notify the buyer if goods are sent by sea so the buyer can insure them, and if the seller fails to do this, the goods are sent at the seller's risk. Now let's move on to the next topic, that is the risk of deterioration in transit. That means this is linked to delivery to carrier. If goods naturally deteriorate during transit, the buyer must bear the loss. Naturally deteriorate means normally wear in transit without anyone's fault. Like for example, fruits ripen and spoil a bit in 3-day truck journey, right? So this is an example of deterioration. Now let's move on to the next topic, that is buyer's right of examining goods. Buyer has the right to examine the goods before accepting them. This is a legal right. So this helps buyer confirm that goods match the contract specification. Next one is acceptance of goods. So once buyer accepts, he loses the right to reject. So this section is critical, that is section 37 is critical. The buyer is considered to have accepted the goods when the buyer informs the seller the goods are accepted, the buyer acts in a way inconsistent with the seller's ownership, the buyer keeps the goods for a reasonable time without rejecting them. So these are where acceptance of goods are done. Now some of the examples are given, just go through it. Now let's move on to the next subchapter, that is fifth subchapter, that is rights of unpaid seller. So who is an unpaid seller? Under section 45 subsection 1, a seller is considered an unpaid seller when the whole price has not been paid or tendered. So tendered here means buyer offered payment but seller refused. So even if buyer is ready with cash, if seller didn't take it, seller is still unpaid. Second one is a bill of exchange or check received as conditional payment has been dishonored. So if buyer gave a check and is bound, seller becomes unpaid. Seller even if he physically got the check. Now let's see the types of rights of an unpaid seller. So first one is right against the goods. So these are rights over the physical goods even if property passed to buyer. Next is right of lien. That means seller can keep possession of goods and refuse delivery until paid. Next one is right of stoppage in transit. If goods have left seller but not reached buyer and buyer becomes insolvent, seller can stop the goods midway. Third one is right of resale. In some cases, seller can resell the goods to another person and claim from original buyer. So these are the three rights exist only when seller still has some control over goods. Second major one is rights against the buyer personally. So here he has the right to sue for the price, to sue for damages, and to cancel the contract. Now the next type of right is right of lien. So lien means the right to retain possession of goods until payment is made. So let's see when seller can exercise lien. So goods are sold without credit, that is cash sale. Buyer must pay immediately. Second one is credit period has expired. If contract gave 30 days credit and buyer still hasn't paid on day 31, lien revives. The third one is buyer become insolvent. That is, even if credit period is running, if buyer gets bankrupt, seller can immediately exercise lien. So now let's see when lien ends. So when seller delivers goods to a carrier without reserving the right of disposal, or when the buyer or agent lawfully obtains possession, and when the seller waives the lien. Now let's move on to the next topic, that is when lien is lost. So it can be lost or it can be ended in three cases, that is delivery to carrier or bailey for transmission to the buyer without reserving right of disposal. So once seller gives goods to transport and doesn't keep control, lien is gone. Buyer or his agent lawfully obtains possession of the goods. So if buyer gets goods, even by accident, seller cannot claim lien again. So seller waives the lien. So once lien is lost, seller must use the next. So that is stoppage in transit. So stoppage in transit means right of an unpaid seller to stop goods while they are in transit, regain possession and keep them until price is paid. So think of it as an extended lien. Lien works when goods are with seller. Stoppage works when goods have left seller but not reached buyer. Now let's see the conditions to exercise this right. So the buyer becomes insolvent, the goods must be in transit. So what is the meaning of insolvent user? So it means a buyer is insolvent when he cannot pay debts in the ordinary course of business or stop paying debts when they became due. Okay, the next topic is when goods are in transit. So goods are considered in transit from the time they are delivered to a carrier or bailey, then until the buyer takes delivery of them. So the transit ends when the buyer takes delivery before goods reach destination, or after goods reach destination, carrier acknowledges that he holds goods for the buyer. That is, this is constructive delivery. So goods reach Kochi Godown, carrier tells buyer, I now hold for you. Even if buyer hasn't physically taken them, transit ends. So next one is carrier wrongfully refuses to deliver goods to the buyer, as well as if buyer rejects goods and the carrier still holds them, transit continues even if the seller refuses to take them back. So for example, if buyer says these are damaged, I reject, carrier is stuck with the goods, law says transit is still on. So unpaid seller can still exercise stoppage and ask carrier to return goods. This protects seller when buyer rejects. So now let's see how seller exercise right of stoppage. So the seller may take actual possession of the goods or give notice to the carrier or bailey who has the control of the goods, or after the notice, the carrier must return goods to the seller, but the seller must pay the redelivery expenses. Okay, now we'll move on to the next topic, that is effect of buyer's sale. So the seller's right of lien or stoppage in transit is not affected by any sale made by the buyer unless the seller agreed to it. However, if the bill of lading or document of title is transferred to a bona fide purchaser, that purchaser gets a valid title over the goods. So bona fide means honest buyer who paid value and had no notice of unpaid seller. Now let's move on to the next topic, that is right of resale. So this is the third and final right against goods. After lien and stoppage, seller can sell the goods to someone else. So the next topic is effect of resale. So if resale price is less than original price, seller can recover the loss from the buyer. And if it's the opposite, the seller can keep the profit. And if there is no notice is given, the seller must give the profit to the buyer. Now we'll move on to the next topic, that is right to withhold delivery. So this is a basic right before we get to lien. So if ownership of goods has not yet passed to the buyer, the unpaid seller can refuse to deliver the goods until payment is made. So this is common issue. If property still belongs to seller, he need not give goods on credit. The next topic is rights of an unpaid seller against the buyer. So besides rights over goods, the seller also has personal rights against the buyer. The first one is suit for price. If ownership of goods has passed to the buyer and the buyer refuses to pay, the seller can sue for the price. Second one is suit for damages for non-acceptance. That is, if the buyer refuses to accept or pay for goods, the seller can claim damages. Then suit for repudiation. If the owner or the buyer cancels the contract before delivery date, the seller may wait till delivery date or treat the contract as cancelled and claim damages. Next one is suit for interest. The seller can claim interest on the price. If contract says payment within 30 days or 12% interest after, seller can claim it. So even if contract is silent, seller can send notice, pay in 7 days, else I will charge interest from today. Interest then runs from notice date and then court decides reasonable rate if not specified. Now let's move on to the next topic, that is buyer's remedies against seller for breach of contract. So here, when seller defaults, buyer is not helpless. So the buyer has three main remedies: suit for damages for non-delivery. That is, if the seller fails to deliver goods, the buyer can claim damages. Second one is suit for price recovery. If the buyer already paid the price but goods are not delivered, he can recover the amount price or amount paid. Suit for specific performance. The buyer can ask the court to order the seller to deliver the goods when goods are specific or unique. Okay, the next one is suit for breach of warranty. If the seller breaches a warranty or if the buyer treats a breach of condition as breach of warranty, the buyer cannot reject the goods, but he can reduce the price, sue the seller for damages for breach of warranty. The next topic is repudiation of contract before due date. So this is anticipatory breach and applies to both buyer and seller. If either party cancels the contract before the delivery date, the other party has two options: treat the contract as continuing and wait until the delivery date, or treat the contract as cancelled and sue for the damages immediately. Now let's move on to the next topic, that is suit for interest. So here the buyer can claim interest or special damages as allowed by law. So this is restitution plus interest. That is, if there is no agreement about interest, the court may award interest from the date the payment was made. Now let's move on to the last subchapter, that is auction sales. So what do you mean by auction? So an auction sale is a public sale where goods are sold to the highest bidder through an auctioneer. So it is not a private negotiation. Auctioneer invites bids openly. Each bid is an offer. Auctioneer's hammer is acceptance. So now let's see the rules of auction sale under section 64. Sale in lots. When goods are sold in lots, Each lot is treated as a separate contract of sale. Second one is compensation of sale. The sale is completed when the auctioneer announces completion by the fall of the hammer. The next one is seller's right to bid. The seller may reserve the right to bid for himself or through an agent only if it is clearly stated before the auction. Seller cannot bid without notice. If the auction notice does not mention seller's right to bid, the seller cannot bid and the auctioneer cannot accept such bid. Next one is reserved for upset price. The seller may fix a reserved price for the goods. The next one is the goods will not be sold below this price. The last one is pretended bidding. That is, if the seller uses fake bidding to increase the price, the buyer may cancel the sale. These are sham bids or puffers planted in the audience. They have no intention to buy. Their only job is to push genuine buyers higher. So with this, we completed the third chapter from Business Laws and Ethics. So up next, we'll be coming with a next chapter. Until then, keep learning and keep growing. Thank you and have a nice day.